If you are traveling to California, your constitutional right to keep arms is perfectly intact. You're more than welcome to keep your guns in your hotel room. However, the only methodology to carry a gun in California is through the issuance of a CCW, and California will not issue you a CCW unless you're a California resident. So, anyone traveling to California, as the Ninth Circuit would so casually suggest, that brings their gun with them and is carrying the gun outside of their domicile is doing so illegally. Now, in today's video, we're going to be talking about a recent development in a case called May v. Bonta, specifically on what counts as a sensitive location. Now, the case is actually a couple of cases that have been joined together. Wolford v. Lopez along with May v. Bonta, and actually a couple of other cases as well. And they all stem from California and Hawaii actually having a response to the Bruen decision. Now, you may remember that with Bruen, the Supreme Court essentially said that states no longer have a tremendous level of discretion in deciding whether or not someone can exercise a civil right. The issuance of a CCW needs to be based on objective criteria. Well, in California specifically, and I'm going to be focusing in on this video on the May decision, since that's the one I'm the most familiar with. In California, the California legislature responded to Bruen by initially crafting a piece of legislation called SB 918. That one actually didn't pass, and subsequently they tried to redo it again, this time through a piece of legislation called SB 2. And SB 2 did several different things. First and foremost, it created sort of a change to the architectural framework on how California issues CCWs, but then it created a list of sensitive locations where you could not carry a gun even if you have a CCW. Now, for those of you who have carefully read the Bruen decision, you might remember that in the original decision, along with the concurring opinion by Justice Kavanaugh, they talk about sensitive locations. And they said, look, at the time of the ratification, there were certain sensitive locations, okay? And just because the state wants to call something a sensitive location doesn't necessarily mean that it is. A sensitive location needs to be articulated with extreme specificity, and it needs to show how there is a high level of passions that are going to be present. In fact, in the original decision in Bruen, Justice Thomas points out that polling locations as well as courtrooms were sensitive locations because it was natural to assume that there would be inflamed passions there. Okay, so be it. But then they also say, look, you cannot say that the entirety of Manhattan Island is a sensitive location. So California decides that they are going to articulate sensitive locations, and essentially they're going to make the entire state of California sensitive, but they're going to do it with extreme particularity. They're going to say you can't carry in hospitals or medical buildings, casinos, schools, banks, sporting locations. Pretty much by the time it's all over and done with, every place that you could go outside of your home. Now, the most egregious aspect of SB 2 was something called the vampire rule. Essentially, it said that we are going to now presume that if there is a private property owner that's opened up their property for public use, read, a business, Barnes & Noble or Abercrombie & Fitch, right? That it will be presumed that the owners of that property do not want you coming onto their property with a firearm. The only way to overcome this presumption is if there is a specifically placed state sign that invites CCW holders to come onto the property. That's the only way. A verbal, hey, Charlie, why don't you come on in, will not be sufficient. You have to have the state sign. If that sign is not present and you do bring your gun inside of that location, then you are effectively engaged in criminal trespass. So a lawsuit was filed called May v. Bonta, challenging the constitutionality of all of these sensitive locations. And right before the law was set to go into effect on January 1, Judge Carney, a U.S. District Judge, issued a preliminary injunction. The state appealed the preliminary injunction. Now, there are all sorts of interesting sort of court intrigue in that initial application, but notwithstanding, up until last Friday, there has been this injunction in place. All of these sensitive locations the state has been prevented from enforcing them. The 3-judge panel last Friday issued its ruling. Now, I want to talk briefly about what an appellate panel does. So there are what we call interlocutory appeals, and then there are appeals on final opinions. Most people are familiar with appeals on final opinions, okay? If a court, a lower court issues an opinion, the losing party appeals that to an appellate court, then the appellate court will review the lower court's opinion, what we call de novo, basically from the very beginning. They look at it as though it's a fresh case. However, if it is an interlocutory appeal, that means an appeal that is taking place during the trial. So the judge issues some form of a ruling, in this case, a preliminary injunction. But the actual trial hasn't happened. That's still several months, if not years away, okay? So it's just a preliminary injunction. This is an interlocutory appeal, and the appellate court cannot review that de novo. They only can use what's referred to as abuse of discretion. They don't analyze the law. They don't second guess what the trial court has done. What they're looking to see is whether or not the judge has simply gone outside the scope of their authority. They're not following the rules. So the state appeals, and the 3-judge panel issues its decision. Now, keep in mind, it's supposed to be based on abuse of discretion. This court recognizes that they are limited by abuse of discretion, but then they issue their opinion as though it is completely de novo. They overturn parts of Judge Carney based on their own legal analysis. This is absolutely 100% a violation of the rules. I would argue that the entirety of the 3-judge panel's opinion that's just been released is in and of itself absolutely invalid. The 3-judge panel has abused their discretion. They've gone beyond the scope of their limited authority as it relates to the preliminary injunction. I don't think that this entire thing is valid. Now, that is going to require an appeal in and of itself, okay? And I believe with that appeal, a re-implementation of the stay, we will have to see what ultimately happens with that. But notwithstanding the entirety of the legal analysis or anything like that, let me give you sort of a bottom line of where in California you could go with a gun and where you could not go with a firearm. So essentially they said, look, the judge was absolutely correct at the lower court level when he said that hospitals and medical facilities, public transit, gatherings that require a permit, places of worship, banks, and the parking areas that are connected to those places, that when he said, though, those restrictions are unconstitutional, they said, we agree with Judge Carney. Those restrictions are probably unconstitutional. Therefore, we will let the injunction stand as it relates to those specific places. They also found that the vampire rule was itself unconstitutional. Now, that's great. Again, fantastic. Love the fact that you came to that level of analysis. But sorry, Ninth Circuit, you're too early. You should not have been doing that in this limited decision. Where they disagreed with Judge Carney, and once again, I don't want to harp on this, but where they disagreed with Judge Carney, they essentially did their own analysis and said, well, our analysis is somehow subjectively better than his, so therefore he abused his discretion because he didn't agree with us, apparently. In any event, they said bars and restaurants, any place that serves consumable alcohol, you cannot have your firearm with you, meaning that if you decide to go to Wahoo Fish Tacos, you cannot carry your gun in there because they serve margaritas, I believe. Playgrounds, youth centers, parks, athletic areas, athletic facilities. I don't know, frankly, whether or not this means a gym. Anything that's controlled by the Department of Parks, Fish and Wildlife, casinos, stadiums and arenas, libraries, because we all know that libraries are locations where there is likely to be inflamed passions. Amusement parks, zoos, museums, and the parking areas that these areas are controlled by. Now, keep in mind, there now seems to be this sort of interesting and odd distinction, right? You can carry your gun into a bank, but you can't carry your gun into a museum because reasons, I guess. Okay, guys, so I'm going to pause this video for just a second. USCCA, which sponsors these videos, is doing a giveaway. It's very cool, but it is ending soon. So you're gonna wanna jump on this. You can read all about it in the description below the video, but like I said, get on this quickly. All right, with that, let's get back to the video. It is also interesting that they end their opinion by inviting out-of-state residents of California to commit a criminal act, which I thought was interesting. So to read it specifically, finally, we emphasize that an analysis about the constitutional limits of what a state ban has no effect whatsoever on the choice of legislatures in other states not to ban the carrying of firearms. That is, a ruling that California permissibly may ban the carry of firearms in, for example, museums, does not have any effect on the choice by another state not to ban firearms in museums. Persons residing in other states are unaffected by California's law or Hawaii's law or our decision, unless, of course, they choose to travel to California or Hawaii with their firearms. Let's talk about that last little missive, okay? Of course, if they choose to travel to California or Hawaii with their firearms. California will not issue a concealed weapons permit to a non-resident of California, meaning that if you are traveling to California, your constitutional right to keep arms is perfectly intact. You're more than welcome to keep your guns in your hotel room. However, the only methodology to carry a gun in California is through the issuance of a CCW. And California will not issue you a CCW unless you're a California resident. So, anyone traveling to California, as the Ninth Circuit would so casually suggest, that brings their gun with them and is carrying the gun outside of their domicile is doing so illegally. they would never make it to the museum. So now we have the Ninth Circuit suggesting that out-of-state residents enjoy some legal right to carry in California, which, by the way, I would suggest that on a constitutional level, they actually do, but we don't have a decision yet on the part of an appellate court actually upholding that. That notwithstanding, what we see here is a clear example that the Ninth Circuit, the three-judge panel that's ruling on this decision, has absolutely no understanding of California's, or I suspect Hawaii's, underlying firearms restrictions. They have an absolute lack of understanding of how to faithfully apply Bruin. And more importantly, they have a lack of understanding how to effectively perform their own constitutional duties. They fully articulate at the beginning of this opinion that we are limited to only reviewing this based on abuse of discretion, and then they frankly throw that out the window in its entirety. This is what happens when anti-gun judges twist themselves into an intellectual pretzel in order to achieve an objective that they are trying to develop. In any event, like I said, this is still in flux. I suspect we're going to see a challenge to this relatively soon. But if you do live in California, as I know many of my viewers do, be cautious when it comes to going into some of those locations that I articulated in this. With that, guys, as always, if you would like to email me, please do so at stephen@artemishq.com. And as always, train constantly, train consistently, train repetitively, and train with purpose. Above all else, stay safe.